Please proceed.
Thank you, Your Honor. May it please the Court, my name is Michael DeLugo from the law firm of Wicker Smith in Orlando, and I would like to reserve 5 minutes for rebuttal, if I may. This is an original proceeding, so we've got a very limited issue that we're presenting to the Court today, and that is whether the term or phrase privileged and inadmissible actually means privileged and inadmissible or just inadmissible. It is our position that the questions that were asked of Mr. Anderson during the course of his deposition, that were asked of Mrs. Anderson during the course of her deposition, as well as the questions that were asked of the investigating officers, all related to what the Andersons told the investigating officers in the aftermath and during the investigation of the automobile accident that is the subject of the underlying lawsuit, all touched on information that is privileged from both discovery and admissibility at trial. It is Ms. Mitchell's position that this is only a rule of admissibility, that it does not preclude the questioning of witnesses during the course of discovery as to what actually transpired during the course of that investigation.
Didn't the prior version of the statute, though, contain language that it was confidential information, and that was specifically amended out? That is correct, Your Honor. The actual phrase was confidential use, which was deleted from the statute in 1989, and that is the crux of Ms. Mitchell's argument, that the case law that we relied on all predate the change in the statute, and therefore I should not have relied on those cases. And in response to that, I would point to this court's opinion in Perez v. State, which is found at 630 Southern 2nd, 1231, in which this court stated in 1994, 5 years after the amendment, quote, "In short, the accident report privilege confers confidentiality upon any information a driver makes in compliance with the statutory duty to report that which occurred in the accident." So this court stated after the term confidential use was deleted from the statute that it's still confidential information. And so we would rely on the Perez decision as it being a demonstration from this court post-amendment that even though the words confidential use were taken out of the statute, that in fact it still remained confidential for the purposes of discovery. We're not always right, are we?
Well,
you don't have to answer that question.
That is a loaded question, Your Honor. There is another example of an appellate decision after the amendment to the statute in 1989 that I would like to draw the court's attention to, and that is the Nelson decision from the 3rd District, which was issued in 2000. And that court stated, quote, "These objected to statements were privileged and inadmissible, and admission thereof constituted a departure from the essential requirements of law." I point to that case even though that was a case dealing with an actual trial, but the court used the term privileged and inadmissible. And Ms. Mitchell is saying that privileged and inadmissible just means inadmissible, and I don't think that that's a reasonable interpretation of that language. And again, I want to emphasize that that decision came out after the 1989 amendment to the statute. There is an issue with regard to, there's no question, I think, that the statute applies to Mr. Anderson, who was the driver at the time. Ms. Mitchell contends that it should not be applied to Mrs. Anderson, but she was an occupant of the vehicle at the time. And so the statements that she made still fall within the privilege. The Supreme Court in Bracken v. Bowles stated just in all candor, this was a 1984 decision, so pre-amendment to the statute. But in Bracken, the Supreme Court stated, quote, "We clearly and emphatically hold that the purpose of the statute is to clothe with statutory immunity only such statements and communications as the driver, owner, or occupant."
And that's a pre-amendment?
Yes, it is, Your Honor.
I mean, because the statute itself addresses only the driver and law enforcement specifically, right?
Correct.
So if we were a Scalia textualist, we'd be hemmed in by that language.
Well, you would be, that is true, and there has been a judicial loss.
It doesn't mean everybody is, it just means that
Correct.
That would be one way of reading that.
One way of reading it. If you're just limiting yourself to looking at the statute doesn't say that directly. However, over the course of time, courts have again and again and again stated that this is a privilege that applies to not only the admissibility at trial, but also during the point of discovery, and it applies not only to the driver of the vehicle, but also to an occupant of the vehicle. That is the Bracken case, and there's also a post-amendment case or I'm sorry, no, this is not a post-amendment case, but this is a decision out of the 5th District called Hochter versus Tucker, and that court stated, quote, "The privilege of the statute extends to all persons within its ambit, those, quote, involved in the accident." So therefore, Mrs. Anderson, we would argue, was involved in the accident, and therefore the statute should apply to her. There is another argument that Ms. Mitchell has made that both of the officers testified that they did not utilize Mrs. Anderson's statements in compiling their accident report. And so in response to that, we would argue that what really matters is whether at the time she was making the statement, she was doing so because she was compelled to do so under the language of the law. Whether the investigating officer chooses not to utilize that information down the line is irrelevant to the issue of whether or not the actual statement that Mrs. Anderson makes to the investigating officer is clothed with that confidentiality or privilege at the time that it's being made. And also I wanted to point out, I know this is going back even further. I tend to resist quoting from cases that are 70 years old. However, I found one that was useful in this instance, and that is the Stevens versus Duke case. That is a Supreme Court decision from 1949, and that stands for the proposition that it is appropriate to apply the statute to the investigating officer's statements as well. We would argue that because we have cited two decisions from the post-amendment, post-1989, that in which courts continue to hold that the statute provides both a privilege and admissibility, that in order for that language to have meaning, that these deposition questions should not have been asked, and the objections raised to them should have been sustained. And therefore, we would ask that the court grant our petition for writ of certiorari on this discovery issue. And unless the court has any further questions, I will yield the floor to my esteemed colleague and reserve the remaining time for rebuttal. Thank you.
Good morning. I'm not esteemed, but I'm Mr. Gowdy here with Mr. Berg, and appreciate you having an oral argument on an original proceeding.
Are we bound to our post-amended statute decisions, which seem to indicate that accident report information is immune from discovery?
You're bound by holdings, and so the only case that's from this court that's post-1989 is the Perez case. And the issue here is not the issue that you were facing in Perez. So
aren't we stuck with Perez?
If Perez held that the statute created a privilege that precluded discovery under Rule 1.2800, you would be stuck with such a holding. But you can go review Perez, of course. That's not the holding of the case. All these cases from before and after 1989 do loosely use the word privilege. I actually went to Black's Law Dictionary, and you can find 2 full pages of definitions of privilege. It's a term that's in the original Constitution from 1787, and it has all types of meanings completely unrelated to what we're here today about. And so I think the question isn't that a court used the term privilege, because that has many connotations, privilege to drive. The question is, when we use the term privilege in 1.280, what are we talking about there? And I would submit we're talking about a right not to disclose something.
Well,
I want to answer a question about Perez, because Perez didn't get into any of this. Perez, the issue there was the driver got out of his car after the accident, and he said something that I'm not going to repeat, but essentially said, "I messed up." And the question was that a spontaneous statement, or was that a statement made for the purpose of the accident report? Because if it's for the purpose of the accident report, then it falls under. And the court said, no, that's a spontaneous statement. And so the holding in Perez was that the statute didn't apply because it wasn't for the purpose. Did the court in Perez, this court, use the word privilege and confidential like lots of other courts? Yes. but it wasn't addressing what we're here today about. So I'm sorry, you had a question that I kind of cut off. I want to make sure.
Well, it's just, I'm hung on the word privilege, and you've done a good job helping me figure that out, because the first thing I think of when someone says privilege is attorney-client privilege. And I know darn good and well nobody can discover anything that falls within the scope of that privilege. So if we have courts using the word privilege as applies to the accident report, seems like that's an ironclad box nobody can get into.
Right, but I think you need to go back to the statutory language. And I hope you are a textualist, whether you follow Justice Scalia or not, because that's what I think all of us should be.
Sometimes I'm not.
Right. Well, that's what all of us should be, because the law is what the legislature's written the law as. And if you look at 316. I have it here in my paper, 316.066 subsection 4, you will not find anywhere the word privilege. And when I submitted yesterday a supplemental authority, it was just the evidence code. And I would encourage the court to try to figure this out, to go back like I did getting ready for this oral argument and reread Chapter 90. And I would encourage you to look at the 400s and the 500s in the evidence code under Chapter 90. And if you look at the 500s, which I'm specifically referring to, 5015, 502, 503, 5035, I can list them all. There you'll find all of the privileges, which you mentioned attorney-client, there's various counselor privilege, there's psychotherapist, sexual assault, marital, accountant-client, clergy, trade secret. Every one of the statutes in the 500s under the evidence code, you're going to find these words. A client or a person or patient or victim, whatever it is, has a privilege to refuse to disclose and to prevent any other person from disclosing. Those are the words you'll find for privileges.
And this one is not there.
It's not in 316.066. What it says in 3106.066 subsection 4 is such report or statement may not be used as evidence in any trial, civil or criminal. That's a rule of exclusion. And I would encourage the court to also go back and reread all of the 400s in Chapter 90, because those are, even though I'll hear lawyers call those privileges, they're not. And what do we have in the 400s? We have things like offers to compromise. We have statements of sympathy that you make at an accident scene. We have offers to plea. We have offers to pay medical expenses. So for example, I'm in an accident, I get out, I run up, I say, I'm really, really sorry. Is that a privilege? No. Is it something we want human beings to do? Yes. So we have a rule of exclusion that that's not going to come into evidence. But am I allowed, as the opposing party's attorney, if I'm in the accident, can the opposing party's attorney ask me, did you say I'm sorry? Yes. Now when we get to trial, it may not come in. Same goal here with the accident report privilege. People are in an accident, they have a right, they do have a privilege against self-incrimination. That hasn't been exercised here under the Fifth Amendment to the Constitution. I know the court's well aware of it from all the criminal cases. That has not been raised. But in order to encourage people to talk freely at an accident scene, to tell the police what they need, we have this rule of exclusion. But it's not a privilege. And actually, one other thing I want to point you to, when just looking at the language, is I pointed you that under the 500s, at every single time it says refuse to disclose or prevent another person from disclosing. You can look at every single one of those. You'll find that language. You won't find it here. What you will find actually under 316.062, which is a related statute, is not only can you not refuse to disclose, if you're in an accident, 316.062 says you must disclose certain information. As a matter of fact, if the police don't show up, you're required under that statute to go file a police report yourself. So not only is there no right not to disclose, the statutes in this chapter, 316, compel you to disclose. The only caveat you see in 316.062 is you don't have to disclose if you want to invoke your right against self-incrimination against the Fifth Amendment. And we're not here on that. They haven't invoked that. So we have a rule of exclusion under the plain statutory text. And it, just like settlement offers aren't considered privileged unless you can, in mediation they may be, and there's a statute about that. But if you and I are having a dispute and I make a settlement offer, what I tell you isn't privileged. And I think what I'd also like the court to think about in trying to call this a privilege is to go back and read the depositions here. So these were of the police officers. And I just told you everybody that you have a privilege with under the 500s. Attorneys, your rabbi, your priest, your psychologist, your spouse. Well, if you read these depositions, it's very odd. These police officers are being instructed by defense counsel to please not answer a question. Now, if that was an attorney, if that was a client's attorney sitting there, or a priest, or a counselor, or a spouse, I can understand that. How can anyone think that what they tell a police officer is somehow confidential, that their attorney can come at a later proceeding and instruct that person not to answer a question? Because it's not a privilege. It's a rule of exclusion. Just like if you and I are in a civil lawsuit and I tell you something in a settlement letter, I can't then go instruct you not to tell somebody unless I've gotten some type of signed agreement by you that this is confidential and I've put a lot of bells and whistles on it, not just because I showed up and started talking. So anyway, it's not a privilege, I think, based on the plain statutory text. I hope I haven't run out of time, but I wanted to address the case law. I already talked about the Perez case. The only other post-1989 case they cite is Nelson from the 3rd in 2000. And there, Your Honor, again, you have to look at what the case was addressing. I acknowledge the courts have been loose in their language, but loose in your language, because privilege means a lot of things, doesn't mean that you've held it's a privilege under 1.280. And in Nelson, the issue there was whether the statute applied to administrative proceedings, and the court held it did. That's not our issue. Did they, just like this court in Perez, the 3rd in Nelson did use the word privilege. I acknowledge that. And then, so really the only issue I think this court needs to decide is, and should decide in a written opinion, because my colleague got a completely different decision in the 11th Judicial Circuit. I'm sorry, a consistent opinion in the 11th Judicial Circuit, and we heard from defense counsel below that for the last 40 years in the 20th Judicial Circuit, he's been arguing this. So I think it would help to get some clarity in the law, because there isn't very much appellate decisions on this. But so I think you just need to come out and say in a written opinion, given the plain statutory text, that this is akin to a rule of exclusion, and it's not a privilege covered under 1.280. If you do decide that this is a privilege, then we have a fallback argument that you heard some about. But I don't think you need to get into that. And that does only with Mrs. Anderson, the defendant's spouse, who was an occupant in the vehicle. First, to clear up something, we're not arguing that if you're an occupant of the vehicle, your statements to the police don't fall under this rule of exclusion. That's not our argument. We haven't argued that ever. Okay? The argument is very simple, and frankly, I think it's one you need to send back to the trial judge once we have the depositions done, which is, were Mrs. Anderson's statements to the police, and again, I'm going to turn to the plain language of the statute, for the purpose of completing a crash report. That's it. We're saying it's not. Why are we saying that? We have sworn testimony from the police officer that it wasn't. What you heard over there is conjecture from their belief. They haven't put on any criteria to establish that this would apply as a rule of exclusion. I think that's going to get teed up in a motion in limine in a pretrial hearing where the judge, under the evidence code, will have to take some limited evidence to determine the admissibility. We've got some evidence that it's not. They can come forward with whatever evidence they want on whether it was. And that just applies to Mrs. Mitchell. And it's really a straightforward argument. But I don't think you get there unless you determine this is a privilege. And that's part of the, I guess I should just segue into that. That's part of the other problem calling this a privilege as opposed to a rule of exclusion. All those things I just mentioned in the 500s, if I'm the client or the patient or the victim of domestic violence, or I went and saw my priest or my rabbi, I can waive a privilege. It's personal. I can say, you know what, I told my attorney that, but I want to disclose it. If you read the case law on this rule of exclusion under 316.0664, it's not like that. It's not waivable by anybody. It's just like settlement or health insurance. That doesn't come in because we don't want it to come into the trial. Am I out of time? But I think I've covered. Oh, I just wanted to briefly, Your Honor. I normally don't bring this up, but we have two appellate fee motions in this case, and I don't want them to get lost. One, I think the parties are largely in agreement. It's based on a proposal for settlement, and we would be asking that the court grant it contingent on us later proving the requirements for proposals for settlement under the statute and the rule. And I don't think opposing counsel and I have much disagreement on that. We do have a disagreement on a secondary one, which is Rule 1. The trial judge, in our view, granted sanctions under Rule 1.380, and therefore we think we're entitled to that same relief here on appeal as was awarded below. We would be asking that you grant that additional motion and give the trial judge the discretion to decide what should be incurred as expenses and costs with respect to this under 1.38A4. And there was an argument made in the reply that we misrepresented the record. That's not true. The trial court did grant sanctions. The written order says plaintiff's request for sanctions is granted with the exception of airfare expenses and expenses associated with the June 25th hearing. The amount of sanctions will be determined at a later evidentiary hearing. And there was also an accusation that we somehow pulled a fast one on the trial judge and got him to write something that he didn't agree to at the hearing. That's not true. I would encourage the court to read pages 34 and 35 of the hearing transcript, which are pages 541 and 42 of the appendix. This is what the trial judge said. I'm going to grant the plaintiff's motion for expenses related with the second taking of those 4 depositions, 2 police officers.
But not airfare.
Right, but not airfare. And then he said, I'm not going to enter an amount. I'm not going to grant plane tickets. So put in your order, we're not paying for another flight up there, but I will reserve if there's some lesser amount.
So has the trial court been consistent in that? It sounds like there's some inconsistency in what the trial court said.
In which way? He just, on the airfare, he just thinks that we should take the depositions by phone.
Yeah.
And we said, if that's what Your Honor wants, we'll either pay for the airfare ourselves or do it by phone. So I don't think there's any inconsistency there. He did deny fees for the hearing below, and I think all we would ask, this is something within the trial judge's discretion, but because we're in an appellate proceeding, as the court knows, trial judges can't award expenses or fees incurred on appeal. And we just ask for another conditional award so the trial judge has discretion to award what he thinks appropriate for the time we've had to spend. I've been involved in these proceedings over privileges before where we go back and there's really not, this has all been a charade. And so we just want the court to grant it contingent and let the trial judge do what he thinks appropriate, and if they want to appeal that later, fine. But we think it's appropriate given that he granted at least some fees below. The last thing I'd point out is if you do right, we have a trial date of July 2018, and we'd like to keep it. And I know the court's very busy, especially with all the Amendment 4 stuff and the criminal docket, but we would hope to keep it. And if the court doesn't have any more questions, I will sit down. I don't see any. Thank you.
You have 5 minutes.
Thank you, Your Honor. Just by way of correction, trial date is July of 2019.
Yes, that's what I meant.
That's okay. I just wanted to make sure it was clear. All right, first, page 35 of the hearing transcript. The judge says, and I'm denying all fees and costs with respect to this hearing. I'll just leave it at that, okay? The hearing transcript says what the hearing transcript says.
That's just for the hearing on this issue, correct?
That's
Right.
correct.
And do you agree with counsel's statement that costs, expenses, and fees except for airfare are awarded for the subsequent depositions?
Yes,
Okay.
yes. But not fees. Okay, well, I would dispute that as to fees,
Okay.
but as to the costs other than airfare, yes, I would agree with that.
But, okay.
Court reporter fees, that sort of thing.
Okay, but no attorney's fees for the second deposition?
That's correct.
Okay.
It's interesting, I think that counsel for Ms. Mitchell sort of made our point. Chapter 316 compels a person, either a driver or a person involved in an automobile accident, to provide information to the investigating officer. That's why this privilege exists, because they are compelled under the law to talk to an investigating officer at the time of the accident investigation. That's why down the line, when you get to the discovery phase of a lawsuit arising out of that automobile accident, there's a privilege, okay? And I think that words have to have meaning. And in this case, we've got multiple courts stating that this is privileged and inadmissible. And in order for that phrase to have any meaning, then we have to say that this is privileged as it relates to any attempt at discovering the content of the statements made to an investigating officer. And the questions were very clear. They were basically asking Mr. Anderson, tell me about your interaction with the investigating officer, and questions to that effect. Well, that goes directly to the heart of this statutory privilege, and I would take issue with the respondents' efforts to say that this is not a privilege, because the courts have used privilege all the time, and you can't just say that courts are using language loosely only when it benefits you to sort of ignore what appellate courts have stated over the course of time. There was one other issue that I wanted to raise. I will leave my argument at that. I also want to thank the court for holding oral argument. I know that there was an administrative order from this court allowing for oral arguments in original proceedings. That's something that the other districts, I think, should take a look at. So thank you very much.
Well, it's an intriguing issue, and your arguments have helped a great deal. I appreciate it.